If you did not see my prior video exposing clear acts of conspiracy and collusion between Menard Incorporated, their third party security company, and now two separate police departments in cities 100 miles apart, the link is below in the description. In August of 2025, I petitioned the court for a fee waiver for costs due to the fact that service related disabilities have made me unemployable. On August 28, 2025, Judge Betters granted my fee waiver, finding that I met at least one of the criteria that makes issuance mandatory under state law. This was a final order, and by selecting this mandatory criteria, the court had no further discretion. The order was final and remained undisturbed for 5 months. This brings us to where my last video left off. After considerable discovery with Menards, their security company, and the city of Mankato, an ironclad conspiracy against rights and bona fide RICO-level enterprise was brought to light. With their own documents and video, I filed for expert witness fees and a motion for partial summary judgment. The corrupt enterprise objected, not just to expert witness fees, but to the involvement of any expert witnesses whatsoever. Under Minnesota statutes, if a litigant was approved for a fee waiver as I was, there is no discretion on the part of the court. If expert witnesses were required a clear mandate in a situation such as this, where there is such a chasm between the parties, between the standards and how events played out, the judge was left with only two choices. The Honorable Mark Betters could either grant the necessary witness fees for policy and medical experts, or rule that my interpretations and beliefs were correct and therefore no dispute existed. The Honorable Mark Betters chose a third option and joined the corrupt enterprise. Judge Betters, without notice or hearing, and without any change to my financial circumstance or request from any party, reversed a 5-month-old final order and revoked my mandatory fee waiver entirely. He did so immediately upon the new evidence submitted, the expert witness request, and a direct on-the-record request from the already state-involved RICO enterprise to interfere with and obstruct any witnesses from testifying. This essentially killed my case without any appealable ruling after substantial discovery. I filed an appeal with the Minnesota Court of Appeals regarding my fee waiver status and the unlawful revocation of a mandatory issued waiver under statute. This is still under review with the Court of Appeals. However, after filing this appeal, Judge Betters immediately retaliated. Again, entirely on his own volition without request from any party, moved to have me declared a frivolous litigant. He barred all further proceedings pending this hearing, essentially imposing prior restraint on my First Amendment right to redress. The court then began rejecting any and all filings. Furthermore, Judge Betters ordered a full review of 15 years of my prior litigation history, a request that precisely mirrored a discovery request from Menards that was denied as overly broad and not able to lead to discoverable information. Menards had been contacting the court to compel this request. Judge Betters just provided the opposing party with information they could not get through discovery without having to issue an order on any motion to compel. I filed a motion to amend the complaint. I added Judge Betters as a defendant in the RICO and civil conspiracy case. I know what you're thinking, and you'd usually be right. Judge Betters has absolute judicial immunity and can't be sued. But how true is that, and does it even apply? First, the actions of Judge Betters were not judicial. They are entirely administrative. That's an exception to judicial immunity, but also a rather complex and subjective argument I am barely qualified to present in pleadings, much less try to explain effectively here. Instead, I will focus on what does judicial immunity apply to, the liability as a whole, or just the penalty itself? A brief summary of judicial immunity from a layperson's perspective. Normally, if a judge commits a crime or an offense under the auspices of his official position, he is immune from civil or criminal penalty. A case requires a claim upon which relief can be granted, either a civil award or a criminal penalty, and in nearly every situation, that penalty cannot transfer from the responsible party. Since it cannot attach to the judge, it simply fades into the void in most cases. However, there's a special section of cases where liability transfers to a third party, a corrupt enterprise, or a conspiracy. Both are claims in this case. Courts have found that a corrupt enterprise is not immune from the acts of an otherwise immune judge defendant. In short, Judge Betters may be immune from the penalty, but the corrupt enterprise is not, meaning he is a proper defendant in the case of corruption and conspiracy. And now we see how far the rabbit hole truly goes. Right now, any legal expert watching would agree that speaking about these things while litigation is underway is a bad idea. Friends, when it goes this deep, it's about self preservation now. Keep an eye out for each other. You're not alone, and neither am I. Hit a like and subscribe.